Privacy laws in Kenya. A comprehensive overview. Kenya has made significant strides in protecting the privacy of its citizens through the enactment of the Data Protection Act, 2019. This law, coupled with constitutional protections, provides a robust framework for safeguarding personal data. Key provisions of the Data Protection Act, 2019. Definition of personal data. The Act defines personal data as any information relating to an identified or identifiable natural person. This includes information such as names, addresses, contact details, financial information, and biometric data. Data controller and processor. The Act distinguishes between data controllers, those who determine the purpose and means of processing, and data processors, those who process data on behalf of controllers. Principles of data processing. The Act sets out principles that data controllers and processors must follow, including lawfulness, fairness, and transparency. Processing must be lawful, fair, and transparent. Purpose limitation. Data should be collected for specific purposes and not used for incompatible ones. Data minimization. Only necessary data should be collected. Accuracy. Data should be accurate and up to date. Storage limitation. Data should not be kept longer than necessary. Integrity and confidentiality. Data should be protected against unauthorized access and disclosure. Rights of data subjects. Individuals have the right to access, rectify, erase, restrict processing, object to processing, and data portability. Data breach notification. Data controllers must notify the Office of the Data Protection Commissioner and affected individuals of any personal data breach. Cross-border data transfers. Transfers of personal data to countries outside the European Economic Area, EEA, are subject to specific requirements to ensure adequate protection. The role of the Office of the Data Protection Commissioner. The Office of the Data Protection Commissioner, ODPC, is the regulatory body responsible for overseeing the implementation and enforcement of the Data Protection Act. It has the power to investigate complaints, conduct audits, and impose penalties for non-compliance. Additional considerations. Online privacy. While the Data Protection Act addresses privacy in general, Kenya does not have specific laws regulating online privacy. However, the Act's principles and provisions can be applied to online activities. Sensitive data. The Act defines sensitive personal data as data revealing a person's race, health status, ethnic social origin, conscience, belief, genetic data, biometric data, property details, marital status, family details, sex, or sexual orientation. This category of data requires additional safeguards. Key takeaways. Kenya has a comprehensive legal framework to protect personal data. The Data Protection Act establishes clear rights for individuals and responsibilities for data controllers and processors. The Office of the Data Protection Commissioner plays a crucial role in enforcing the law. Individuals and organizations operating in Kenya should be aware of their rights and obligations under the Act. Resources. Data Protection Act, 2019. Link to www.odpc.go.ke